Welcome to the Dealing with Divorce podcast, where we bring together family law professionals from around Georgia to help you deal with divorce. Today we've got Vanessa Sykes with Hulsey, Oliver & Mahar, and she practices in family law, and she is also a Guardian Ad Litem. Thank you for joining us, Vanessa.
Thank you for having me.
And tell, what is the Guardian Ad Litem role? What does that mean?
Well, a Guardian Ad Litem in Georgia does have to have training, but does not have to be an attorney. So I am an attorney, which I feel like enhances my role as a guardian. But you do have some training, and then you serve in a role where you are the court's witness, and you have the opportunity to investigate and speak with the parties, with the children, with relatives, school teachers, counselors, doctors, anybody that may be helpful in providing information to answer the question of what custodial arrangement is in the best interest of the children. And then at the conclusion of the investigation, I usually work with the attorneys and seeing if we can settle with my recommendation, but then I ultimately prepare a written report that the judge reviews as evidence during a hearing. I also testify as the court's witness, so there's some exceptions to the hearsay rule that apply for a Guardian Ad Litem, so it can be a very cost-effective way to have a final hearing because I can testify about what the teacher told me, what the counselor told me, what the doctor told me, without needing to bring those people to court as well.
So is Guardian Ad Litem like a fancy word for a custody evaluator, or is that different?
It is different than a custody evaluator. Because in my experience, a custody evaluator typically has more training as a psychologist or a counselor, and they aren't concerned so much, I don't think, with the legal aspects of the case. As a Guardian Ad Litem, I'm always kind of keeping in mind what the statutory requirements are for custody, the factors of something like grandparent custody, that sort of thing. I focus more on that as a Guardian Ad Litem than I think that a custody evaluator would.
And when you're acting as an attorney for one side, do you talk to the children?
Generally not. When I am an attorney in a case, I don't think there's any specific rule that prohibits you from doing that, but generally I do not ever meet the children in a custody case if I'm acting as an attorney for one of the parties.
Okay. And how about, what in your past prepared you to interview children and to be a Guardian Ad Litem?
Well, early in my career, I worked for the district attorney's office as an assistant district attorney. And so I did have the opportunity in that job to prosecute crimes against children. And I worked a lot with forensic evaluators who are specially trained, usually counselors, who can interview children in a way that doesn't re-traumatize children, and also that doesn't sort of, the idea is not to plant ideas in a child's head, to get truthful descriptions from the children about whatever happened. And I found that work really interesting, working with children, working with the professionals who do work with children. I have my own children, which doesn't make me an expert, but I definitely enjoy kids. I feel like I get along well with them. And so when the opportunity to serve as a Guardian Ad Litem came up, I jumped at it. And it's really one of my favorite parts of my job.
What age are your children?
I have a son who is 20 and a daughter who is just about to turn 17.
Oh, boy. And so how is it different talking to a very young child versus a child who's reaching the upper ages of childhood?
It's very different. So obviously with a baby or a toddler, you're not really having a conversation with them so much as observing how they interact with their parents or other caregivers. And so that's just a really interesting way of doing my job where, I might say hello to the child or, a little back and forth, but it's more of just watching. And you can see when a child is comfortable with someone, if they're, climbing all over their mom or their dad or giving them hugs and kisses, you can tell they feel comfortable. You occasionally will see where the child almost feels like a stranger to that adult and is either afraid or just really not interested in interacting with them. And that's the extent of my interactions with that child. I'm not going to try to question the child about custody or anything in depth. When they're an elementary school age child, I'm much more interactive with the kids, and it's really sort of child-led. There's some children who just really won't ever feel very comfortable with talking to an adult. I'm not a counselor. I meet them a few times. But then there's some kids who the minute I walk in the door are just happy to chat with me. And I generally will want to talk to them. I like to meet the kids once at mom's house, once at dad's house. If it's a grandparent visitation or something like that, once when they're with their other caregiver. And then I really like to follow up with an independent meeting with the child, usually at school. And during those discussions with an elementary age child, I'm not ever going to ask the question, who do you think should have custody? Or, whose fault do you think the divorce is? Or something like that. I'm asking open-ended questions, but not geared to put the child in a role of having to choose their own situation. I feel like kids shouldn't have a job. Mm-hmm. They shouldn't be for mom or for dad. And so I will talk to kids just more about what do you like about mom's house, what do you like about dad's, I talk about school and their interests, and sort of from hearing from the kid overall, learning about where they feel most comfortable and where they might be happiest spending most of their time. So I really don't like it when a child comes into a discussion with me as a guardian ad litem. It's very clear when they've been given an agenda. Mm-hmm. And the first thing they say is, I want to live with my dad. That makes me actually quite concerned that there's been coaching or pressure, because again, I don't think a child should be responsible for something like that. When I'm dealing with a teenager, and it varies. Sometimes there's a 12-year-old who really has a lot to say, and it's I'm going to have a more interactive discussion with them about custody. But if I'm dealing with a 15-year-old or a 16-year-old, we're going to talk as grown up as they are willing to talk about mm-hmm. things. And kids are smart. Kids live in a house and know what's going on, even when parents think that they don't. And so a teenager can really give me a lot of feedback about what's really happening behind closed doors, which I think is very important. And if a teenager wants to voice an opinion about who they live with primarily, I think it's important to give them that voice, and the law does allow them to have that voice. And so generally what I'll tell a teenager when I'm talking with them is, if you do what you're supposed to do, follow the rules, do good in school, go to school, do the things that you're supposed to do as a kid, that shows me that you're mature enough that I should really take into consideration what your opinion is about where you live. If I have a kid that's gotten into the drama of a divorce case, and, is really acting out and acting immaturely in response to whatever's going on at home, I certainly understand that it's a chaotic environment, not really their fault. But obviously I'm going to take with a big grain of salt what they tell me about where they want to live, because they may not be making a decision that's in their own best interest. So it really changes how I interact with the child, how old they are.
Mm-hmm. So how would you dig into figure out if a child was just wanting to stay with a parent just to maintain the peace, because that parent was like the one who causes a lot of the conflict? That's something that Judge Davis had mentioned in a prior podcast. How do you deal with something like that, or get to the root of it?
It's hard because you may not see it right away. And in my experience, I will see that a child will tend to align with the parent, sometimes the parent that they get along best with, like mm-hmm. that's just natural. But sometimes a child will align with the parent that they're afraid of losing. And so, every once in a while there's those awful cases, and I'm sure you know about them. But one parent may just be the type of person, I'll just use a woman as an example, but it's both women and men.
Be like vindictive.
Hateful. And basically you'll see the message is, if you like dad, I'm not going to like you. Mm-hmm. And it's just, it's of course no one's going to say that to me. So it takes time to see that happening. But I do see that happen, and it's by no means every case, but I do see it happen where a child seems to be pushing away a parent for no real reason other than that their other parent hates them. Mm-hmm. And over time, those are the children that I probably will talk with more, and eventually I do hear from the child that, they feel like if they show affection for the other parent, the parent that they're aligning with is going to push them away. And so, that's just something we've got to work through, and I definitely will address that in my recommendation. And I usually try to approach the parent that's doing that, but historically that doesn't go very well.
Mm-hmm. So what's the timeline look like as far as a guardian ad litem investigation?
A simple one, maybe a teenager election, or a case where really we're just wanting to maybe sort out an issue like a medical issue or a school issue, might be 2 or 3 months. I've got a caseload of my own, and so it takes some time to set up meetings and make a recommendation and move forward with mediation and a hearing and things like that. A more in-depth investigation is anywhere from 9 months to sometimes more than a year. I have a few cases that I have been working on for more than a year, and those ones, it's not like I'm working every day and generating bills every day, but in some of the more complicated cases, we will have sort of like an initial recommendation, and let's see how that works. And so we might be working under a temporary order to see if a particular schedule works, or we might be waiting to see if Dad's looking for a job. Is he going to be in Hall County, or is he going to be in Cobb or in Atlanta, and maybe see how that shakes out. So sometimes a case is longer, not necessarily because it's a problem. I just really like
moving pieces
and changing lives, and there's a lot of upheaval for everybody, and I like to see how somebody is doing in a situation, if at all possible. I mean, I'd love to make a recommendation where we already see, hey, this is working, the child's happy, doing good in school, doing their activities, still getting to see both of their parents regularly. Then that really makes me feel confident when we go to court for a final hearing about my recommendation.
So how do you get document evidence? Do you have the right to discovery the same way a lawyer would?
Yeah, I'm given authority by the court's order, which is supported by a uniform superior court rule. And the court's order specifically says that I'm permitted to have access to school records, physicians, counselors, schools. I can also make recommendations if I feel like a parent needs to submit records to me. Of course, they'd have to sign an authorization. I can't just go to a doctor and get whatever I want. But I am given that authority to make those requests. And generally, the parents are expected to support that, because generally parents have asked for me to be involved in the case. And so if in the rare occasion a parent opposes me, let's say, for example, going to a school, then that's something we can address to the attorneys and if need be through the court. But generally, if I'm asking for something, the court wants me to be able to review it, and I have that access.
So if in the process of, getting all this information, you see something that, hey, this needs to be done, do you have any authority to tell the parents that, hey, this needs to be done?
Yes, and I don't have the authority to make people do things because I'm not the judge. I have the authority to make suggestions. And so this came up very recently in a case I'm working on. The child in question is in 5th grade and has really bad grades. And she's going every day. She's very bright and articulate. And the teacher told me she's doing her work. She's just not performing on tests. And really not just a B, but like failing. And that's really going to be a challenge for her as she goes to middle school if she's already struggling. And so I brought that up to both parents. So I don't want to appear like I'm blaming anyone or favoring anyone, but I just said, have you seen this? And you might want to reach out about getting an evaluation done to see if she has a learning disability so she can get some accommodations. And the response was actually great. Both parents who don't like each other love their daughter and responded to me pretty quickly and were like, we've already been in the talks and that evaluation is going to happen this summer. And so I actually didn't have to make them do anything, but I am permitted to make that suggestion. And then the response I got was really wonderful, that 2 people who are in conflict with each other were able to unite in communicating with me. So like gold stars for them. It was actually a great part of my investigation. I was really happy to see.
Yeah, absolutely. So in circumstances where a child has special needs, how do you kind of determine which parent's going to be best able to deal with those special needs?
Oh, that's a challenge. And sometimes we've got to let them try and see. I have a case that I'm working on where one child is profoundly deaf and needs to communicate with sign language. And obviously, I think that they've kind of acknowledged this. One parent is much more fluent in sign language than the other. And so they're actually acquiescing to the child should probably live primarily with that parent. And I want to focus on getting that other parent up to speed so that they can openly and completely communicate with their child. And not that they don't care about their child or anything like that. It's, you know, a lot of times I'm learning, say with someone who's profoundly deaf, they have a lot of communication skills that are not American Sign Language, just from living in a family and knowing each other. And so, like, certainly this child can communicate with his other parent, but we need to make sure he can really communicate and that his friends can and that sort of thing.
Yeah.
So that's how I deal with a situation like that, is learn more about the disability and learn about what's needed to provide a healthy, safe, happy home environment and education for that child with that disability, and then look and see, you know, are both parents able to accommodate that? Are they not? I have been a guardian ad litem for some profoundly disabled children. One child was in almost a vegetative state and obviously just needed huge amounts of care. And again, one parent was the go-to during the marriage, who kind of handled everything. The other parent obviously loved his child, but was just experiencing more challenges in handling employment as well as all of the needs that came with a child with so much special needs. And so, same thing in that situation, though, I learn about what they need, and it's not really a contest between the parents. It's not, you know, I think in those situations, one parent may say, well, I'm the one that's always done it, so I always should. And I don't really look at it that way, because I'm looking at, we're starting a new form of your family, and what can we do from this point forward to provide the most happy, healthy, supportive experience for this child. And a lot of times it is the parent who has been doing most of that historically, but it doesn't have to be, if that makes sense.
And so, I guess, does the investigation, would you say that helps or hinders the settlement process?
I think it really helps. I, as a divorce lawyer, love having a guardian ad litem. When I am a guardian ad litem, where I think it's helpful is I really internalize that I am the court's witness and I am only on the child's side. So it really helps me to see where each parent is coming from, and perhaps another caregiver if there's a grandparent or something involved. I definitely am interested in hearing what they have to say, but I don't care if all of them are mad at me at the end. I'm not looking for to make one person happy versus the other. The only thing I care about is making a recommendation that I truly think is best for the child. And it's really helpful to be able to have that role. If I'm unhappy with someone, I tell them. If I think they could do something differently, I tell them. If they need to give me information, I tell them. Whereas when you're an attorney, I do always think about the children involved in my cases, but when you're an attorney, you are hired to represent one person's side. And I generally don't talk to the other party ever in a case, and I generally don't talk to the children either. So I'm really getting like a skewed point of view when I'm acting as someone's attorney, and I think that's a great role to play. But as guardian ad litem, I really feel like I'm helpful because I can see where everyone's coming from. So I'm almost a mediator in a way, because I can really see where the sources of the conflict lie, and I'm always trying to help resolve those sources of conflict. So like the example I gave you about the child with the grades, it was really great to see that education is not their issue. Like they will work together. And so I'm always looking for those things to find out what really is the problem. In that family, the problem is not school and education. Like they unite together on
They're on the same page, yeah.
So it's I think a really helpful role. I would say the vast majority of my guardian cases do settle.
Okay, that's good. And so does the guardian have to approve the settlement, or are they in the room with the parties? How does that work in mediation?
Typically at mediation, to save expense, I'll be on call. So I'm only really paid if I have to do any work. I'm always
That makes
happy
sense.
to attend mediation, but it makes for a really expensive day with the mediator, the attorneys, and a guardian. But I have gone to some mediations. And under the Superior Court rules, I have to approve any custody arrangement. So I'm not, I am interested if someone's paying child support, because I think that's helpful to know, if you're supporting your family. But I'm not interested in what arrangement they reach for child support, and I'm not interested in what arrangement they might reach for, distribution of their other property. So I'm really only focused on the parenting plan that they're able to come up with. And I always provide some sort of recommendation before mediation. So I want to be kind of an open book. And I don't think it would be helpful to go to mediation when you don't know what I'm going to be suggesting to the court. So I usually will provide a letter or an email just detailing what I've done and then what I'm going to be suggesting. So sort of an abbreviated report. My reports are often 60 or 70 pages, so I save that for if we absolutely need that for court. But if they reach an agreement at mediation, I will almost certainly sign off on it unless it's just something outrageous. I've never had a mediated agreement.
That was going to be my next question. Is have people ever agreed to something that you wanted to fight against? But yeah,
I'm trying to think of. No, I haven't had anyone agree to something that's just because you figure they usually have attorneys and they're not going to agree to something that's just not allowed by law.
Yeah, I've never run into that either.
And I feel like who knows better for what's best for their children than the two people who are their parents.
Absolutely. So what are some red flags that a child might have been coached? What are things you look for?
When a child immediately starts telling me about what they want for custody, it's a huge red flag. Now, like a 15-year-old, that's different. They know why they're talking to me. But when like an 8 or 9-year-old, the first thing they say is, I want to live with my mom, or I want to live with my dad, that's a red flag to me. Also, if a child talks to me using words and phrases that don't seem to be consistent with what a child that age would use. And so there's some exceptionally bright kids, but most 8 or 9-year-olds are not going to be talking about child support and visitation and custody schedules, sort of like legal terms that, like, why would they be thinking about that? And so that gives me a red flag to kind of explore that. Where are they hearing that from? Why is that information coming to them? Some kids will just have like a litany of things about one parent that they dislike. And they'll come in like ready, and it's like they've practiced, like not just 1 or 2 things, but like 10, 12, 15 things, and then she does this, and then she does that, and then she does this. And then I'll say something in response to that, like, can you tell me some good things about your mom? And they'll be like, no, nothing. And like, that's, again, just a red flag. It may be that mom is absolutely awful. I don't know. But typically, someone's not all good or all bad. And if their child can't think of one single positive things to say about them, it's sort of a sign that there may be some coaching going on there.
Are you a mandatory reporter?
I am.
So, and what's the line between, this is something I should address in my report as opposed to this is something I need to mandatory report and have something happen right now?
I know I have reported, I think twice. Both times were, and I'm sort of just thinking about the facts of the case, both times involved sexual conduct.
Okay.
And references by the child. Actually, neither one of them was there a concern that a parent had perpetrated. But both times the child referenced conduct. One time it was just I felt like I had to report. It was just not appropriate, but I didn't really know that anything criminal had happened. And another time, the child made a comment to me that if that was true, that a crime had occurred. And in both situations, I tell counsel that I'm making the report. Like, I'm not an ambush type of person, but ask them to keep that to themselves for the time being. And then I make the report, and I don't question the child any further. It's really important to me to keep in mind that I'm not a trained forensic interviewer. And so I'm always very careful to not ask the child any questions that I think are leading them. But also, if there is concern of abuse happening, I don't want to do anything that might taint the child's recollection of events or their possible testimony later.
All right.
I would get a forensic interview done as quickly as possible, I guess is what I'm trying to say.
Gotcha.
If there's something that I am reporting, I'm encouraging a forensic interview to be done.
Okay. So what about drug use? If someone tests positive for drugs, is that something that would need to be reported?
In my attorney world, yes.
Okay.
When I was not acting as a guardian ad litem, I was told that the child had reported a mound of powder on a table that Dad was snorting next to a handgun, of all things. And I was like, that's absolutely terrible.
That could cause death.
Yeah, that was why they came to see me. But of course, they hadn't seen it because they weren't living in the home. But we did make a report, and that was investigated. So yeah, there are some situations where I think that you're, you have to get law enforcement involved. Now, if someone has a positive drug screen for a pill that they're not prescribed, or for marijuana or something like that, I may not feel that that's a situation that I need to be a mandated reporter on, but absolutely that's something that I need to take some kind of action on, for sure.
Sure. And so what about, I lost my train of thought. Oh yeah, so what if somebody has a meeting with you tomorrow for a Guardian Ad Litem initial meeting? What's some steps that they can take to make the most out of that first meeting with you and make a good impression?
I think just being willing to be open and honest, to really focus on not so much villainizing the other party as but focusing more on the child and the issues that parent sees with the child. And just really openness is huge. When someone says, here's all our emails, you can have any photos you want. You can come over anytime. I'll go ahead and sign the authorizations. When they're open and honest like that, it makes me feel like we're developing a good rapport right away. And that way I can just ask them questions and feel like, they're going to respond and I can follow up on their answers. When someone approaches me guarded, unhappy about my involvement, unwilling to let me, there's some parents who don't want me interacting with their child without them around. It's not necessarily a huge problem, but it definitely puts things off not on the best foot for me.
Are there any things in the law that you feel like impede, or is there any kind of legislative change that you feel like would really help you in the role of Guardian Ad Litem?
I'm very happy with the authority we have as a Guardian Ad Litem and access. I find it really difficult to navigate the issue of marijuana use because it doesn't matter what my personal opinion on using marijuana is, but it's illegal in the state of Georgia, but it's legal other places. And it's much more socially acceptable to use. So I have a lot of families where mom and dad may have smoked marijuana together or eaten gummies together, and then now that they split, one of them will claim it's a problem. And it would be really nice if we had a consistent, criminal statute that I feel like is consistent with the reality. I feel like the criminal statute's not really used, and that's probably a good thing. I'm not saying people should be punished if the courts don't want to punish them, but if and some judges are more harsh on it than others, and so
that's what I was thinking. Does it create a equality
crime,
issue far as equal protection under the law?
It's very challenging because am I supposed to be drawing a hard line on it or not? And it's I would love to just have kind of a more clear set of legal authority for how to treat usage of marijuana. And I presume that change is coming, but I thought it would have come long before now.
Are there any books on child psychology or on dealing with custody issue or anything that you have really been helpful to you that you would recommend?
I have a few friends who are child psychologists, and that's been really helpful to like be able to just talk to someone who's not involved with the case, but to kind of share their thoughts. That's been a great resource for me. And then I really got a lot out of the book, The Sociopath Next Door.
Okay.
Because it's the adults who can be so challenging. And the most high conflict adults are, I feel like, different than regular people. So I don't know that I deal with sociopaths necessarily or narcissists necessarily, but I sure do deal with people, some who are just really awful people. And it was just helpful to read that book and kind of gain some insight on where someone like that is coming from.
Yeah, and you mentioned before we got started with the podcast that you like the podcasts on murder mysteries or something.
Yes.
So
True crime.
that kind of goes into that as well.
Yes.
So what's your favorite podcast?
Oh gosh, it's always changing. I mean, I love like Dateline and 2020. I feel like I've listened to like almost every single true crime podcast there is. Right now, I'm listening to Life After MLM, which is multi-level marketing.
Mm-hmm. Yes.
It's really random, but it's really a good podcast and interesting. I like learning about why people do the things they do.
Yes, absolutely. Well, thank you so much for joining us today,
thank you for
Vanessa. I
having me.
appreciate your time. This has been the Dealing with Divorce podcast. See you next time.